AGO into EFG2 trust account towards the CR17 campaign. In October 2017, during the President Ramaphosa's election campaign, it is also not in dispute that the President's son had business contracts with AGO, for which he was paid large sums of money for the services he rendered. The issue for my determination is whether or not the President, as the then Deputy President and Member of Parliament, was duty-bound to declare the financial benefit accruing to him during the campaign, and whether his failure to disclose such financial benefit was in violation of the Executive Members' Ethics Act Code. On 11 March 2019, President Ramaphosa submitted a supplementary statement to my office, which ostensibly setting out issues of conflict of interest and the obligation of members of the National Assembly to disclose financial interest received in their private capacity as political parties, as opposed to such gifts and donations received while performing their official responsibilities. The President stated that during a discussion between me and him regarding the 1,000 donation that was paid by AGO into a law firm ABSA trust account towards his campaign, I seemed to suggest that the donation amounted to a benefit and that it ought to have been disclosed. He stated that he became of Parliament in May 2014, and thereafter he was appointed Deputy President of the country. In that capacity, he said he disclosed interests as required by the Executive Ethics Code every year. He said further that he did so since his election as President in February 2018. Doing the provisions of the Code, he said he disclosed his share and financial interest in companies, corporate entities, sponsorships, gifts, and other hospitality benefits of a material nature, foreign travel, land and immovable property inside or outside South Africa, and pensions. He indicated further that he was aware of his duty to disclose such information in relation to his spouse and his dependent children, to the extent that he was aware of them. In fact, he was aware of what needed to be disclosed. He said that his son was not dependent upon him for financial support. He said he was not obliged to disclose any of his financial interests. The President indicated that since becoming the Member of Parliament of the Executive, which requires for the President to publish a code of ethics prescribing standards and rules to comply with, he has also performed accordingly. He to the Executive Ethics Code, where it states that the members should or must comply, or he complied per this Executive Code. He submitted that the provisions indicated that the target of the Executive was to regulate members in their performance of their official responsibilities and not internal political party election donations. The President further noted 2C of the Act, which published must require members to disclose any financial interest acquired after the office, including any gifts, sponsored, foreign, and everything, or their families. And he's indicated he did disclose. And he made the following disclosure: financial interest. He also disclosed the benefits of any nature which he received and any donations. The President submitted that the donation was not in return for any benefit by him in his official capacity. nor was it in order to influence him in the his duties. He said the donation was instead received to support an internal party election. In the President's view, there is a distinction between donations made towards a campaign fund for a political party's elective conference that received by members in their official capacity or in an attempt to influence the member in the performance of their duties. The latter two instances would reasonably be subject to prohibition. He contended that it could never have been the intention of the legislature to regulate donor funding for internal political party elections. According to him, it was clearly the intention of the legislature to regulate the provision of gifts and benefits to members in return for benefit received by a member in the official party, or in an attempt to influence the member in the performance of the member's duties. He indicated that the donation related to an internal party political, as I've indicated above. The President indicated that currently in law there was no obligation in South Africa for members to disclose their sources of private funding for an internal political party election, and it would be unreasonable and irrational to prohibit or require that he disclose such donations. Simply put, it cannot be that every person who may also be a member contest internal political party election will be expected to disclose their donors. That's what the President argued. He further indicated he was not aware of any person in a political party who was a member who received a donation towards their campaign in an internal party election being obliged to make public or list of donors to their campaign. He referred to Section 2.2 of the Executive Act, which states that the disclosure of a benefit is required, firstly, if it is a material benefit, and secondly, if it is received by the member. Although the donation may be regarded as material in nature, the President said it was not received by him. Instead, it was received by the CR17 campaign. President Ramaphosa also stated that he had no knowledge of the donation and therefore could not reasonably be expected to have disclosed it when it was made. In the light of this, he said that paragraph 4.1 of the Code of Ethics only prohibits the solicitation or acceptance of a gift which is in return for any benefit received by a member in their official capacity, or constitute improper influence on the member, or constitutes an attempt to influence the member. Added that in such circumstances, appropriate to either require the disclosure of an offer of such benefit or to prohibit the solicitation. However, he indicated that the donation was neither offered, solicited, nor by him. Reasons. The President added that although the donation was made, maybe so, as I've indicated above, that it was not donated. Based on this argument, the President stated that he did not believe that he had failed in his duties to disclose. Section 196, in fact, Section 96, 1 and 2 of the Constitution, as I've indicated above, states that members of the Cabinet must follow the Code of Ethics prescribed by national legislation and may not act in any way that is inconsistent with their office or expose themselves to any situation involving of a conflict between their official responsibilities and private interests. In the Constitutional Court case, FF and the Speaker and the DA, it was very clear that the President knowingly or unwittingly exposed himself to a situation risk conflict between his official responsibilities and private interest was exhaustively dealt with. In the matter that gave rise to that court case, the Nkandla investigation, the public protector's finding on the violation of Section 96 was based on the self-evident reality. The features unrelated to the president checked against the list of what the South African police security experts themselves determined to be security features were installed because the people involved knew they were dealing with the president. When some government functionaries find themselves in that position, the inclination to want to please higher authority by doing more than is reasonably required or legally permissible, or to accede to a gentle nudge by overzealous and ambitious to do a little wrong here and there may be irresistible. However, the person in the position of the president should be alive to this reality and guide its occurrence. Failure to do this may constitute an infringement of this provision. To find oneself on the wrong side of Section 96, all that needs is a risk. It does not even have to materialize. There is a touchstone report which we have issued. It's party bloodlines. It's a 2015-16 report which I've used as a touchstone in this matter. And the issue entirely was about conflation of party political activities and the state events, where sometimes members would be regarded or purported to have acted in their personal capacities and therefore violating the executive ethics code due to blurred lines between their responsibilities in the circumstances where the state and party roles tend to overlap. Deriving from the above legal prescripts and case law, it can be safely argued that the campaign pledges towards the CR17 campaign were a form of sponsorship, and that they were direct financial sponsorship or assistance from non-party sources other than a family member or permanent companion, and were therefore benefits of a material nature. President's failure to disclose the said material benefits, including a constitute the breach of the code. President Ramaphosa received assistance from any other than the member's party which benefit the member in his or personal and private capacity, because as a presidential candidate of the ANC, he received campaign contributions which benefited him in his personal capacity. Being the deputy president of and a member of parliament at the time, President Ramaphosa was therefore duty-bound to declare financial benefits accruing to him from the campaign. It cannot also be argued that the financial benefits did not accrue to President personally, merely because it was deposited account of CR17. I have evidence which indicates that some of the money collected through the CR17 campaign account was transferred into Cyril Ramaphosa Foundation account. I have also established that the president hosted several dinners where he participated himself and addressed the donors. Therefore, in my view, that is actively participating. Further, I have evidence which confirms regular updates to President Ramaphosa on the operations of the CR17 by the campaign managers, his directives to them about payments of the money into the CR Foundation, as well as being asked by the campaign managers to speak to certain donors. Consequently, politicians are under no express legal obligation to disclose the sources of their private funding at elections or any other time. However, on the contrary, different consideration applies when it comes to individual political party members who may be members of parliament and cabinet ministers at the same time, and who in their private capacity obtain sponsorship, solicit gift in whatever disguise form, or obtain any other benefit of a material nature to aid them in their competition for party leadership positions. Therefore, they cannot to seek a refuge behind the party political activity label, as they should comply with the applicable ethical code of conduct governing their conduct as members of parliament or the executive. 96 of the Constitution requires cabinet members to act in accordance with the code, and that they should refrain from acting in a way which is inconsistent with their office or exposing themselves to situations involving the risk of a conflict between their official responsibilities and private interest. Based on the aforesaid, it is therefore my view that private activity or interest may cause cabinet members to violate the provisions of the Executive Members Ethics Act. Further, a person in the position of the Deputy President, as President was then, is required by the standards of ethical conduct set by the provisions of Section 96 of the Constitution and the Code to have been concerned about the obvious extravagant and expensive donation into a trust account that was used to raise funds for his benefit. In any reasonable person's opinion, it is expected of the President to have interrogated the source of these donations. Although found by the CR17 campaign managers that the deliberate of the identity of the donors and the amounts donated by them from the President was to avoid the perception that his goodwill will be bought, the primary reason, in my view, should have been to avoid any situation of capture of the President that might compromise his decision-making in the future. Instead, the President accepted these donations. Was this solicited donation of 500,000 by Mr. Gavin Watson, the owner of Agor, the company that had a contract with the Department of Justice. The matter looks at the issue, a conclusion that direct sponsorship of one's political campaign for political party leadership qualify as a declarable sponsorship, and that is inescapable. President Ramaphosa's failure to disclose financial interest which accrued to him as a result of these donations, accordingly to a conduct that is inconsistent with the office as a member of cabinet and violates Section 96 of the Constitution. The last question that I wish to deal with is whether there is an improper relationship between President Ramaphosa and family on one side and Agor, and the nature of the payment of this 500,000 passing through several intermediaries instead of a straightforward donation to the CR17 campaign, thus raising suspicion of money laundering. This is the last. It is not in dispute that this money was paid. I've taken you through into the EFG2 account. This EFG2 was the trust account of the attendee receiving donations for the CR17 campaign. And Mr. Piet Venter confirmed that he was told or instructed by Mr. Gavin Watson to pay this 500,000 into, in fact, to approach his PA, Ms. Natasha Oliver, to pay an amount of 3 million into this Miyoto trading. Mr. Venter is one of the directors of Miyoto. So Mr. Miyoto received this 3 million, but was told that there is a 500,000 which must be paid into an account belonging to the president's son. That's what he said he was told. And this 3 million was deposited, 500,000 was paid into this EFG2 account, the 2.5 million supposed to be deposited into another account. The president, in case he was not involved in the fundraising process, and this was the campaign which was led or directed by the campaign manager, and also repeating, or we've used the same information that he indicated that he told them he doesn't want to be involved in the whole process. According to the president, at the meeting, has told him that this EFG2 was the one which donated to the CR17 account. The investigation team prepared subpoenas to the key witnesses or role players. As I've indicated, I had 2 meetings with the president. I interviewed Ms. Nicole, I interviewed Mr. Mkhwebane, Mr. Chauke. I received an affidavit from Andile Ramaphosa, the bank involved in the transactions, an affidavit of vendor, which also interviewed. I interviewed Mr. Watson. So the interviews which are conducted with Mr. Mkhwebane, one of the 2 CR17 campaign managers who submitted an affidavit, indicated that he was one of the members of the fundraising committee, along with Mr. and Nicole. According to him, they had decided early in 2017 to approach donors for the CR17 with a clear condition that the donors should not expect any favors in return for their contributions to the CR17 campaign. There was also a conscious decision by the committee members, as well as agreement with the President Ramaphosa, that he should not know the identities of the donors. And the members, in fact, as the members of the committee, they decided to come up with possible donors whom they decided to approach capacity and not as directors or owners of businesses. Mr. indicated that he is the one who approached Mr. Gavin Watson, and he knew him for 20 years, and he approached him and requested him to donate to the CR17, and he consequently gave the business name, Nicole, so that the money, they can speak to Nicole, since she was the one who was managing the finances, to deposit the money. Mr. Mkhwebane indicated that a decision had also been taken by them not to do anything in writing, therefore no records or documentation such as project plan, minutes of meetings were kept for the CR17 campaign. According to him, Mr. Chauke, Bejani Chauke, was the overall leader of the CR17 campaign, whilst Ms. Nicole was the facilitator of things for the campaign. Mr. Mkhwebane indicated that he was responsible for approaching Mr. Watson for the donation, and Mr. Mkhwebane indicated that he knew Mr. Ramaphosa from their days as members of National Union of Mine Workers. President Ramaphosa was also present at some of the dinners which had been organized by the CR17 campaign managers for the donors, where he would address them and he would naturally meet and greet the benefactors. Mr. Mkhwebane also indicated that during their fundraising drive, they had raised more than 200 million for the CR17 campaign. I also conducted an interview with Mr. Chauke, one of the campaign managers. He had his legal representatives. In fact, all of them had legal representatives assisting them, not representing them, as he had submitted a sworn affidavit. Not expect any favors when they contribute to the campaign, and that they will, as well as the not disclosing the identities of the donors to the president. Ms. Nicole confirmed that the president stated that she had been the one who alerted him to the inaccuracy of his response to Parliament and corrected him that this EFG2 trust account belonged to attorneys. Ms. Nicole stated that she knew President Ramaphosa for quite some time. In fact, they worked together at Chanduga, and then she also indicated that she's one who approached them about the idea of asking for donations for his campaign. Ms. Nicole also indicated that it was agreed that the identity of the donors, amounts pledged, should not be revealed to the president, contrary to the evidence which I have in my possession. However, she was unable to concern I raised about the pre-screening or vetting of donors for purposes of eliminating the ones who might be tainted, such or who would negatively affect the campaign as well as the integrity of the president. Also confirmed that Mr. Mkhwebane indicated that during the interview that they might have collected around 200 million. Notwithstanding the by the CR17 campaign, to me that it had been agreed that identities of donors and amounts should not be disclosed to the president. Evidence adduced has revealed the contrary. Evidence in my possession in the form of emails, invitations, instruction to confirm that the president was constantly informed of the CR17 campaign by the campaign managers, whereupon his advice and approval to specific matters would from time to time be sought. I have therefore established that in addition to having potential donors during the banquet function where he delivered keynote addresses, evidence further confirmed that the president had further and broader interactions with the donors, some of whom he knew very well. Although I did not conduct interviews with Mr. Andile Ramaphosa, he made submission to my office in the form of an affidavit in which he explained his relationship with AGO. This was confirmed by the advisory mandate and the anti-bribery and corruption policy. Mr. Shivamboni's complaint had made a specific request to me to investigate and confirm whether indeed there was a contract between Mr. Andile Ramaphosa's company, Blue Crane Capital, and AGO as indicated by the President in his response. Mr. Andile Ramaphosa also submitted bank records which showed transactions of monies paid by AGO into Blue Crane for the services rendered. He also denied having a trust foundation linked to which had received the 500,000 which was paid by AGO through Miyoto Trading. He also submitted invoices generated and in respect of services which have been rendered. According to bank statement provided to my office by Mr. Ramaphosa, which he received about 4 monthly payments of 171,000, which in total was around 600 from AGO for the period mentioned above. I then interviewed Mr. Fenter, whose affidavit was primarily the source of this investigation. I then also interviewed Mr. Watson and Natasha Olivier, who was AGO's private secretary. Mr. Fenter indicated that he was working as a tax consultant in 2017 for AGO. He was called by Mr. Watson to his office. Upon his arrival, was then taken to Ms. Olifier's office, who is AGO's company secretary. Mr. Olivier was instructed by Mr. Watson to transfer 3 million into the account of Miyoto Trading, a small company which belonged to Mr. Fenter and his sister. Mr. Fenter was then handed a piece of paper with bills, where Mr. Watson was instructed him to transfer 500,000 to an EFG2 trust account, which he was told was the trust foundation account of Mr. Andile Ramaphosa. He was informed by Mr. Watson that the description of the transfer of 500,000 should be social development, and he did as he was instructed. Mr. Watson had also instructed him to transfer 2.5 million into the account of Ms. Lindy House, which he did on 19 October 2017. But he informed me that the transaction was, however, cancelled and this money was transferred back later, this 2.5, which was given to Lindy House. Apparently, for some reason or some unknown reason to the matter, this Ms. Lindy House was no longer willing to receive this money. According to him, the affidavit referred to by Mr. Maimane in his complaint was prepared on his behalf, and that certain parts of what is reflected in it is not all true, and certain things that have been changed. However, everything pertaining to the 500,000 is true, Mr. Venter stated that in fact he had signed the affidavit referred to under duress. Mr. Venter further that Mr. Watson and Agor took advantage of his small company to effect some of their financial transactions and that he was unable to refuse, hence the instruction to him to transfer the 500,000 instead of using their own accounts. During my interview with Mr. Gavin Watson, he admitted that he donated an amount of 500,000 towards the CR17 campaign after having been approached by Mr. Mutlatsi to do so. According to him, there was nothing untoward with his donation. As a long-standing member of the ANC for more than 40 years, and he used to contribute financially to the ANC party elections campaign, even during the former other presidents, before President Ramaphosa. However, Mr. Watson also stated that in the past he had donated to the ANC as a party and not to individuals, as it was the case now, where he had to donate to both CR17 and NTZ individual campaigns. Also to express a concern to me that he thinks that this was a politically motivated attack on him by the opposition party. Mr. Watson confirmed, although he did not attend all the dinner functions organized by the campaign managers, he was present at one which was hosted by the president. From the bank records at my disposal, there had been several constant transfers of money between Agor, Concilium and Mioto Trading, amounting to large over a period of time. I also proceeded to interview the PA to Mr. Watson, who confirmed the transfer of 3 million and out of that the 500,000 into EFG2 account. And I also interviewed the 3 directors of attorneys, the firm of attorneys, Edelstein, Faber, and Krobler, in order to get more information on how they administered the EFG2 trust account of the CR17 campaign. They were also assisted by their legal representatives during the proceedings. So, one of the directors, Mr. Berry, who is a former director of EFG2, stated that he had been approached by CR17 campaign managers, in particular Ms. Nicole, to open a trust account dedicated to the campaign, which he did in compliance with all legal requirements. According to him, it was with a specific mandate and clear forward instruction on how the account will operate. Subsequent to verifying their bank and their audit with the bank and their auditors, Levin Howard, EFG was given a go-ahead to open the account for CR17. He then indicated that although Ms. Ronelle Krobler, one of the directors, was not involved in the physical opening of the account, she dealt with the transfer of funds to beneficiaries on instructions from CR17 campaign managers, mostly Ms. Nicole. However, the bank records reflect her as one of the signatories of the bank mandate when the account was opened. Ms. Krobler, on her account of what transpired, confirmed that what had been said by Mr. Berry, and that she would get telephonic instructions from Nicole to pay X, Y, and Z company. In conclusion, the EFG directors indicated that the account was always audited and the balance sheet was sent to the Law Society. I need to mention that the advocate who was helping them was quite uncooperative, as he was from the onset raising unnecessary objections, which he continued to do throughout the proceedings, whereas we wanted just to get assistance from the EFG2. Evidence of disbursements of funds from EFG2 trust account to several beneficiaries, including Riadenda Trust, Linked Environmental Services, and Cyril Ramaphosa Foundation. I had also subpoenaed bank records of EFG2 accounts, 2 bank accounts involved in the above transaction, to establish how the alleged trajectory of the money occurred, so as to determine whether such movement was not improper as alleged by the complainant, that there was suspicious movement of money and suspicion of money laundering. From the evidence received by my office, I can confirm that 500,000 payment was transferred from Watson's personal account as part of a lump sum of 3 million into the account of Miyoto Trading and eventually into EFG2 trust account, which is an attorney's trust account of CR17. I can also confirm that large sums of money were transferred by various benefactors into the EFG2 trust account for the CR17 campaign, from where it was dispersed by the attorneys to several beneficiaries. I've named just a few: Ria Tender Trust, Linked Environment Services, and Cyril Ramaphosa Foundation, but there's there's a number of other beneficiaries who were paid. From the evidence received by my office, an amount of more than 191,482,000 was deposited into the EFG2 trust account between 6 December 2016 to 1 January 2017, and during the same period this amount was transferred out of this account. Another bank account, there's an amount of 388 million which was deposited into this Ria Tender Trust between 1 January 2017 to 20 February 2019, whilst nearly the same amount, 388,518,000, was transferred out of this account. Another information is that an amount of 41,179,000 was deposited into FNB account of Linked Environmental Services between 15 December 2016 to 13 February, and during the same period this amount was paid to several beneficiaries. About 335,000 rands was transferred from Linked Environmental Services into the Cyril Ramaphosa Foundation, and some of the monies which were paid out of all the donations received for the campaign. Records reflect that there were three single largest donations of 30 million on 9 March 2017, more than 39 million September 2017, and over 51 million on the same date into the EFG ABSA trust account. We've the records from ABSA, but they never cooperated, but we had to get the records. In conclusion, on the above revelations related to use of large sums of money, some of which received from private companies, I will express my preliminary view. A scenario, when looked at carefully, creates a situation of the risk of some sort of state capture by those donating these monies to the campaign. Section 12 of the Prevention and Combating of Corruption Activities Act provides that any person who directly or indirectly accepts or agrees or offers to accept any gratification from any, whether for the benefit of himself or herself, or for that other person, or gives or agrees to give to any other person gratification in order to properly influence in any way the promotion, execution, procurement contract with a private organization, corporate body, or any organization, the fixing of the price, consideration of other monies is provided, is guilty of an offense. Section PACA also provides for an all-encompassing general offense of corruption. In terms of this section, anybody who accepts any gratification from anybody else or gives any gratification to anybody else to influence the receiver to conduct himself or herself in a way which amounts to the unlawful exercise of any duties, commits the act of corruption. PACA also criminalizes specific corrupt activities relating to, amongst others, public officers, contracts and procurement of tenders. It also recognizes between corrupt activities and other forms of crime such as organized crime and financial crimes, including, for For instance, a criminal may attempt to integrate the funds he or she received from corrupt activity, such as a bribe or kickback, into a financial system by channeling funds through complex financial transactions during which he or she may involve several entities as conduits and use financial institutions as a means to disguise the corrupt source of funds as well as the ultimate beneficial owner of the proceeds of the activity. My investigation into the issue pertaining to the possible money laundering is premised on the above legislation dealing with corruption, and not only applies not who offer bribe, but also to private individuals who accept bribe, a corruptor and a corruptee. It would therefore have been remiss of me not to deal with the aspect of the complaint so as to be dispelled with such suspicion as referred to in the allegations brought before me by the complainants. Section 64C(1) of the Act provides that the Public Protector may at any time prior to, during or after the investigation, if he or she is of the opinion that the facts disclose a commission of an offence by any person, bring the matter to the notice of the relevant party charged with prosecutions. Based on the facts before me as well as evidence adduced during my investigation, I come to the conclusion that there is a merit to the allegation relating to the
What a morning, a news-busy morning.
Busy morning indeed. A lot of breaking news on the agenda's watch. Public Protector Advocate Busisiwe Mkhwebane has found President Cyril Ramaphosa guilty of breaching the Executive Ethics Code.
She says he allegedly misled Parliament about his financial benefits from Busasa. She was probing whether the 500,000 donation to Ramaphosa received was ethical. Of course, as you could see there, that presentation is still ongoing. We just happened to lose the line.
One of the things that she did say in terms of her finding was regarding whether on the 6th of November 2018, remember the DA lodged this complaint during a question session in Parliament. President Ramaphosa deliberately misled the National Assembly and thereby acted in violation of the provisions of the Executive Ethics Code and Code of Ethical Conduct and disclosures of members' interests for the Assembly and permanent council members. And this is what the finding was. The allegation on that, the 6th of November 2018, during that session, that President Ramaphosa deliberately misled the National Assembly is substantiated. So that is one of the findings.
And also going into detail about what led her to this decision, that he deliberately misled Parliament based on the different interactions she has had with him, with his team, the CR17 team made up in the name of Mr. James Mutlatsi, who many people will know as a leader of the National Union of Mine Workers, and Mr. Bejani Chauke, who were the leaders in the CR17 campaign, who have come in to say the money was deposited to the campaign trust, and the total amount of monies that were benefited, that this trust benefited, was 200 million rand. And he says that she was able to corroborate the process of putting the money into these accounts.
I just see a statement from the Democratic Alliance that they are having a media briefing with regards to this. So that's at 12 o'clock. So keep locked onto SABC for that.
Okay, it's a goodbye from us, I suppose.
I think we've got Ralph Mateka, political analyst, who's on the line. Mr. Mateka, thank you very much indeed for your time. Look, it's been a busy